My Lords, Honorable the Chief Justice, my Lords, Honorable Judges of this Honorable Court, Honorable former Judges of this Honorable Court, Chairman Bar Council of Telangana, Additional Advocate General, the Public Prosecutor, the Deputy Solicitor General of India, the President High Court Advocates Association, the Director Judicial Academy, the Member Secretary Telangana State Legal Services Authority, the Secretary Legal Services Committee, Member Bar Council of India, the law officers and other officers, senior advocates, members of the bar, family members of Honorable Justice LALITHA Kanneganti, ladies and gentlemen. We have assembled here today to bid farewell to our beloved judge, Honorable Srimati Justice LALITHA Kanneganti, on her lordships being transferred to Honorable High Court of Karnataka. Her lordship was born to late Srimati Kummineni Ankamma, Sri Kummineni Ankamma Chowdhury and Srimati Maheshwari, a reputed family of Cheruvu Jammulapalem village, Bapatla Mandal in Guntur district. Her lordships did her schooling in St. Theresa's High School, Erragadda, and her intermediate from Nagarjuna Junior College, SR Nagar. Her lordships graduated in arts from Sarojini Naidu Vanita Mahavidyalaya, Nampalli, Hyderabad, and pursued bachelor's in law at Padala Rama Reddy Law College, Usmania University, Hyderabad. Her lordships enrolled as an advocate on 28th December 1994 in the Composite Bar Council of Andhra Pradesh and commenced practice by joining the chambers of Sri M.R.K. Chowdhury, Sri K. Harinath and Sri O. Manohar Reddy. Her lordships thereafter began her independent practice within a short span of time. Her lordships had a very successful practice spanning across all areas of law, including civil, criminal, constitutional, taxation, service, non-service, motor accident claims and matrimonial cases. Her lordship was the standing counsel for the Agriculture Market Committees, English and Foreign Languages University, Tirumala Tirupati Devasthanam Endowment, Sri Venkateshwara Vedic University, Sri Venkateshwara Institute of Medical Sciences, and Sanskrit University, Tirupati. Her lordship was elevated as Judge of the High Court of Andhra Pradesh on 2nd May 2020, thereafter transferred to our High Court and assumed charge as the Judge of this court on 15th November 2021. Her lordship started her practice as an advocate from this very High Court. Her lordship's connect with the members of this bar is immense and strong. She has treated the members of this bar as her own. The Telangana legal fraternity shall always remember her contributions for years to come. The younger members of the bar have developed a great sense of gratitude towards her, inasmuch as lordships during her short but memorable tenure here has inculcated in them discipline, confidence, and values of hard work and sincerity. Her lordships over the years has rendered numerous landmark judgments that reflected her lordship's deep and wide knowledge of law, keen sense of understanding, and appreciation for the underlying objective of any law, and a meticulous examination of the case on hand. It is only apt to quote a few judgments of her lordships on this occasion. In Trisha Chandran versus the Superintendent Cherlapalli Central Prison, a writ petition filed seeking removal of 2 death row inmates in solitary confinement. Her lordships held that the right to live with human dignity is a right guaranteed under the Constitution of India to all its citizens, and it will also apply to the prisoners Just because they are prisoners, they cannot be put to any kind of inhumane treatment unless the behavior of the convict is such that it requires a keep such convict in a solitary confinement by way of punishment. Our lordships also held that merely because they are death convicts, they cannot be put to under solitary confinement. Her lordships also elaborated on the objective of imprisonment while observing that the prisoners should be provided with such an environment whereby they will evolve as a better citizen, and solitary confinement will have a very bad effect on the psychological aspect, which deprives the prisoner of all his personal rights. Hence, the action of the respondents in confining the death convicts in separate cells was found to be the most unwarranted by her lordships, with a direction to remove the convicts from solitary confinement and to permit their movement within jail by treating them equally with the other prisoners in the prison in their access to the basic facilities. In Bharat Kumar versus State of Telangana, a criminal petition for anticipatory bail and the accused had sought for the order copies on the same day in fear of being apprehended by the police. In this regard, Lordships noted that though bail petitions are heard and decided by the court as expeditiously as possible, there is difficulty and the delay in dispatching the certified copies of the orders to the advocate, clients, as the certified copy has to pass through several phases of scrutiny and approval. Our Lordships considered Article 21 and noted that the right of an accused to have his bail application heard by the court within a reasonable time has been entrenched as a constitutional liberty. Our Lordships observed that since the disposal of bail applications without furnishing the order copy within a reasonable time will not place the accused in a better position, and mere emphasizing that an accused has an indefeasible fundamental right to bail itself is not sufficient without furnishing the copy of the order passed. Our Lordships passed a series of directions, including that it is not necessary for an accused to submit a certified copy of the bail order in order to get bail, and that a e-copy of the bail order from the online website of the concerned court is sufficient for the purpose of getting bail. In Goli Sai Koti Vali Prabhu versus the state of Telangana and others, the accused had approached the court seeking quashing of the lookout circular issued against him by the police, though Section 41A notice has already been issued and charge sheet has been filed with regard to a case registered against him for the offences under Section 498A, 323 and 506 of IPC and Sections 3 and 4 of the Dowry Provision Act. Her Lordships, while directing the police to withdraw the lookout circular against the accused, Lordships in the reasoned verdict observed that there was no basis for continuing the LOC after issuance of Section 41A CRPC notice and the subsequent filing of charge sheet, more so in view of the fact that the circular issued by the Director General of Police instructing that whenever Section 41A CRPC notice is issued or whenever the bail is obtained by the accused, concerned police shall address a letter to the commissioner and the commissioner in turn shall address a letter to the immigration authorities to close the LOC. In case Avia versus the station house officer, the writ petition was filed questioning the action of police in forcing the petitioner to compromise the case with the accused. The petitioner had given a complaint to the police and the same was registered. And instead of conducting investigation into the alleged crime, the police were forcing the petitioner to compromise the matter with the unofficial respondents, and they were not conducting proper investigation and not filing the charge sheet. Our Lordships ruled that inaction by the police in day-to-day activities cannot be decided in writ petition and a private complaint has to be filed. Our Lordships observed that it was no doubt true that when a complaint is given and a cognizable offence is made out, police have to register a crime and conduct a thorough investigation and file the charge sheet. However, any lapse on the part of the investigating officer cannot be a ground for the petitioner to approach the High Court, and stated that for a person aggrieved by such action, inaction of the investigating officer, the appropriate and efficacious remedy available to it to file a private complaint against the said officers before the competent court. In Syed Inayatullah versus State of Telangana, Lordships, while dealing with an anticipatory bail filed by the application, in a case registered for the offences punishable under section 406, 420, read with section 34 IPC, has observed that after issuance of notice under section 41A CRPC, if the police feel that the accused has to be arrested, then without obtaining permission from the magistrate concerned, they cannot arrest the accused. Her Lordships further clarified that if the accused feels that the police failed to follow the procedure under section 41A CRPC or the guidelines of the Apex Court in Arnesh Kumar's case, they could file a contempt petition against the concerned police officer with relevant material to substantiate their allegations. However, her Lordships also underscored that merely on this basis that the police is not giving any acknowledgement, a person cannot seek anticipatory bail. In Messrs. K. prestigious launch Hookah and Cave, the state of Telangana, a writ petition was filed seeking to issue an appropriate direction regarding banning and interfering with the restaurant and coffee shop business of the petitioner in serving of flavored hookahs and consequently direct the police not to cause any hindrance or restrictions to running his business. Her Lordships, after examination, the provisions of cigarettes and other tobacco products, prohibition of advertisement and regulation of the Trade and Commerce, Production and Supply and Distribution Act 2003. The judgment of the Apex Court held that the police have the power to regulate smoking in public place in the manner specified as provided under sections 4 and 12 of the Act. The Lordships noted that the object of the Act is to prohibit consumption of cigarettes and other tobacco products which are injurious to health in the larger interest of improving the public health. In the larger interest of improving public health, if the restaurant obtained trade license for the purpose of running a restaurant and is exclusively running hookah centers in the guise of running a cave, since as per section 4 of the Act, a separate place is required to be maintained for restaurants which have the capacity of 30 seats, that ipso facto will not give any right to the restaurant owners to run the hookah parlors. Thus, if on the basis of the license granted for a restaurant, exclusively hookah centers are being run, the authorities have a right to cancel the license. Therefore, invariably, the police have to have a constant check and control whether the concerned are following the provisions of the Act and the rules, and whether they are displaying statutory and pictorial warning notices. Her Lordships also observed that according to Article 47 of the Constitution of India, since it is the duty of the state to protect the public health, there cannot be any direction to the respondent's authorities or police to not visit hookah centers of the petitioner. Her Lordships also noted that under the guise of hookah parlor, in some cases, they are getting the customers used to the other narcotic drugs and hence held that there should be a constant surveillance and checking by the police. In Pakala Narasimha Reddy versus State of Telangana, writ petitions were filed by the petitioners questioning the action of the respondent authorities in issuing the proceedings under section 636 of GHMC Act, whereby he was directed to remove the unauthorized construction within 24 hours, failing which action will be taken, and that without even waiting for the said period, contrary to their own notice, the respondents have removed the structure. Her Lordships, while disposing of the writ petitions, observed that Honorable Apex Court in Municipal Corporation of Greater Mumbai and others versus Sunbeam High-Tech Developers Private Limited has laid several guidelines to the municipality as to when, where and how they can carry demolition. Her Lordship directed that Principal Secretary, Municipal Administration and the Municipal Commissioner GHMC shall communicate the orders passed by the Honorable Apex Court to all the concerned in the state, and whenever and wherever they are proposing to demolish, the municipal authorities shall act upon only after issuing the show cause notice, taking into consideration the explanation submitted by the parties on merits and further in accordance with the guidelines issued by the Honorable Apex Court. Her Lordships further held that if the petitioner is claiming compensation, he is at liberty to approach the proper forum, if any available under law. Her Lordships is married to Sri K. Vijay Prasad and blessed with a son, Mr. Gautam, and a daughter, Miss Manasa. Her Lordships conduct the court proceedings in a very disciplined and strict manner. Her Lordship is very encouraging of the younger members of the bar. In a judiciary that has Capacity of women judges. We need more judges like her lordships who are epitome of hard work, sincerity, wisdom, and incredible mental ability. It is only when we have judges like her lordships who constantly inspire the daughters of our country will see a more balanced, representative, and gender equal justice system. It is high time that this aspiration becomes a reality. As Swami Vivekananda once said, there is no chance for the welfare of the world unless the condition of women is improved. It is not possible for a bird to fly on only one wing. And we very much hope that her lordships will fly to the zenith of our judiciary very soon, which will help in making this aspiration a reality. We wish her lordships all the best for the future, and we will fondly remember her lordship's time here in the future when we see her lordships further rise to the higher echelons of our judiciary. Thank you.
My esteemed colleagues on the bench, Mr. B.S. Prasad, Learned Advocate General for State of Telangana, Mr. J. Ramchandra Rao, Learned Additional Advocate General, Mr. A. Narsim Reddy, Chairman of Bar Council of Telangana, Mr. P. N. Rao, President, Telangana High Court Advocates Association, Mr. Gadi Praveen Kumar, Deputy Solicitor General of India, learned senior advocates, learned members of the bar, registrars of this court, Director Judicial Academy, Member Secretary, Telangana State Legal Services Authority, Secretary, High Court Legal Services Committee, officers and staff, members of the High Court, friends from press and media, family members of Srimati Justice Lalitha Kanneganti, ladies and gentlemen. We have assembled here to bid a farewell to our sister Srimati Justice Lalitha Kanneganti on the eve of transfer to High Court of Karnataka. Every transfer has a silver lining. Sister Srimati Justice Lalita's transfer as a judge of Karnataka High Court would certainly give her an opportunity to be part of one of the oldest high courts of our country, which has glorious traditions. I had been a judge of Karnataka High Court for more than 4.5 years, and I feel that it's a great opportunity for her to enrich in diverse fields of law. Srimati Justice Lalita Kanneganti was born late Shri Kanna Chaudhary and Srimati Amreshwari, and hails from a reputed family of Guntur district, Andhra Pradesh. She did her schooling from St. Teresa School and intermediate from Nagarjuna Junior College, SR Nagar. She graduated in arts from Sarojini Naidu Vanita Mahavidyalaya, Hyderabad, and obtained bachelor's degree in law from Padala Rami Reddy Law College, Osmania University, Hyderabad. She has been an outstanding law student. She got herself enrolled on 28/12/1994 in Composite Bar Council of Andhra Pradesh. She started her career in the office of Shri M.R.K. Chaudhary, Shri K. Harinath, and Shri O. Manohar Reddy. Thereafter, she started her own practice in all areas of law, including civil, criminal, constitutional, taxation, service, non-service, motor accident claims, and matrimonial matters. Srimati Justice Lalita was the Standing Counsel for Agricultural Market Committee, English and Foreign Languages University, Tirumala Tirupati Devasthanam Endowments, Shri Venkateswara Vedic University, Shri Venkateswara Institute of Medical Sciences, and Sanskrit University, Tirupati. Considering her legal acumen, merit, and suitability, she was elevated as Judge of the High Court of Andhra Pradesh and took oath as such on 2nd May 2020. Thereafter, she was transferred to this court and assumed charge as such on 15th November 2021. During her tenure, Srimati Justice Lalita Kanneganti has disposed of 7,790 cases and 6,672 miscellaneous cases. The law reports bear testimony to her competence and caliber. I am sure that she will have a memorable tenure as judge of Karnataka High Court. I, on my own behalf as well as on behalf of judicial fraternity of the state of Telangana, pray God Almighty to shower His blessings on Srimati Justice Lalitha Kanneganti for a successful tenure as Judge of High Court of Karnataka. We also wish better half Shri K. Vijay Prasad, her son Mr. Gautam, and daughter Mrs. Mansa all the good health, wealth, and happiness. Thank you.
Honorable Chief Justice, esteemed sister and brother judges, Sri B. Shivananda Prasad, Learned Advocate General, Sri K. Pratap Reddy, Public Prosecutor, Sri J. Ramchandra Rao, Learned Additional Advocate General, Sri Palle Nageshwar Rao, President Bar Association, Sri A. Narasimha Reddy, Chairman, Bar Council, Sri Gadi Praveen Kumar, Deputy Solicitor General, respective senior members of the bar, government pleaders, standing councils, and other learned members of the bar, registrars, lawsuit researchers, staff, members of the print and electronic media, my friends and family, ladies and gentlemen. Warm afternoon to all of you. At the outset, I express my gratitude for the kind words spoken about me by the Honorable Chief Justice and the Learned Advocate General. For a person like me, who felt more comfortable spending time with my judicial work rather than remaining active in social life, speaking on occasions like this to express my feelings is a much difficult task than passing orders. However, I shall try my level best. My venture in the field of law was completely accidental. Though I aspired to become a doctor, my late father, Shri K. Chaudhary, believed that a better future awaits me in this noble profession. In spite of going on a 2-day hunger strike, my father's opinion remained unchanged. Though not fully convinced with his decision, I joined the law course. Today, without any hesitation and fear of contradiction, I admit that entering the legal profession is the best decision of my life and shall always remain grateful to my father. As a young lawyer, I had the opportunity of learning from some of the greatest judges and doyens of the bar. The support and encouragement they have extended has been instrumental in shaping the career of this first generation lawyer. The legal profession is referred to as a noble profession as lawyers are entrusted with the enormous task of upholding justice. While I was at bar, I enjoyed each and every moment. The kind of joy, happiness, sense of satisfaction that one derives in this profession is uncomparable to any other profession. I often argue with my cousins abroad that their happiness is limited to the day they receive the paycheck. On the contrary, in this profession, every day is a new experience as you have an opportunity to address the concerns of people who are in need of justice. The smile on the face of the client when he gets a favorable order keeps the lawyer motivated all through. Even after entering the profession, I had never thought nor expected to be on this side of the dais. But as destiny would have it, I had the opportunity and privilege of becoming a judge of this wonderful institution. Discharging my judicial functions gives me utmost satisfaction. I strongly feel that judicial time is very precious and expensive. Neither the bar nor the bench can afford to waste it. In pursuit of this, sometimes I might have raised my voice, but I have no other intention but to give timely justice. I have always tried to see the litigant behind the lawyer and can say this with a clear conscience that I have not made any decision based on its consequences for me. While discharging my duties, it was always in mind to be strong but not rude, to be kind but not weak, to be bold but not lazy, to be humble but not timid. The institution of judiciary is a ray of hope to the common man, the ultimate consumer of justice. I do not agree with the school of thought that the role of a court comes to an end on passing of an order. An order which is not implemented serves no better purpose than an order which was never passed. Non-compliance of court orders has been the most significant barrier to courts in providing timely justice to litigants. Being liberal in contempts will further encourage the "we will get away with it" syndrome of the contemnants. As rightly said, the silence of the lawman is more harmful than the violence of the layman. The other aspect on which all of us should ponder upon is pendency of cases. It's a huge challenge that is posed to the institution. If cases continue to remain pending for years together, people will lose hope in the system. When I discuss about pendency with friends, the general reply is, even before I was here, there was pendency. While I'm here, there is pendency. And when I leave the institution also, there will be pendency. For that, I can only say that I may not be able to clear the pendency, but I do not want to contribute even a single case to the existing pendency. From the last 4 months, I have been in the roster of motor accident appeals up to the year 2010. In most of the cases, accidents have taken place in late 90s and some in early 2000s. It is so unfortunate that even after 20 years of the accident, the appeals are still pending. The Act being a beneficial legislation, the purpose will be achieved if the parties receive the compensation when they are in pain and need of money, even if it is a single rupee. After 20 years, even if enhanced compensation is granted, we cannot say that we have done substantial justice. I believe that if 2 accident appeals per day are given to each of the judges, the pendency can be reduced in no time. Though I didn't have the good opportunity of working with Honorable the Chief Justice, from what I have learned from the colleagues at Karnataka, I am optimistic that under his able guidance, the goal of higher disposal can be achieved. My address would be incomplete if I do not speak about the bar. The bar of Telangana is a strong, independent, disciplined, and learned bar. It is second to none. I would like to acknowledge that my relationship with the bar has been pleasant and happy throughout. Having been at the bar for over 26 years, I am conscious of the problems faced with the bar. Keeping it in mind to the extent possible, I have accommodated them. I cannot forget the love and affection showered on me by the members of this bar. I am truly indebted to each one of you. It means a lot to me. This institution has a glorious past and a bright future. I try to contribute to the best of my ability. My advice to all the young friends here is to work diligently. Success is bound to follow. Live by your principles because success is sweeter when you reach your destination through straight path. Failure, which is a product of principle living, is better than success, which is founded on compromises. Just because something is not happening for you right now does not mean that it will never happen. Do not lose hope. I always try to maintain my composure in the court. If at any time I raise my voice, it's only in the interest of institution, not otherwise. If I have hurt any member of the bar, my sincere apologies. It was unintentional. I'm conscious of my shortcomings and limitations, despite which members of the bar have been courteous and respectable to me, which I shall be ever thankful. Today, I remember my father, late Shri K. Chaudhary, who passed away in September 2020, 4 months after my elevation. He lived an exemplary life and is my source of inspiration. As he could not attend my swearing-in ceremony in person due to his ill health, he sent a message which I shall treasure forever. I quote, "My dear Lalitha, on behalf of the family, I wish you all the best. I pray the God to protect your mental brevity, strength, and wisdom in upholding the justice to a common man in need during your tenure of office on the bench. Uphold clean and unflinching loyalty to the law of justice, which shall express your concern to the common man in need of the same. I wish you a comfortable tenure of office throughout." Unquote. This is indeed a roadmap for my career, and I shall always remain grateful to him. I must place on record my sincere appreciation to the learned Advocate General and his team of law officers. During my short stint as a judge of this court, they have provided good assistance and cooperation. Though a judge is a visible face of justice delivery system, what goes on behind is a sheer dedication and hard working of many. I must express my appreciation for the assistance rendered by the registry led by Registrar General Mrs. Sujana. In discharging my duties as a judge, a vital role is played by the staff. I've been extremely lucky on this count. I must express my appreciation for the excellent work done by my personal secretary, Mrs. K. Sri Lakshmi Devi, women of high integrity and efficiency, but for whom it has been difficult for me to perform my work satisfactorily. The successful working of a court in session depends to a large extent upon the efficiency of the court officer, and I had the benefit of the efficient services of Mrs. Saraswati. I would be failing in my duty if I do not acknowledge the assistance rendered by court masters attached to my court, Mrs. Janki, Mrs. Varalakshmi, Mrs. Anuradha, Ms. Maithili, and last but not the least, Idris, my law researcher. They are like my family with whom I have spent more time. The little that I could dispose is only due to their efficiency. I also acknowledge the services of my PSOs, Sai and Tirupati, driver Akbar, staff at the court, Suresh and Satyam, staff at my residence, Narsimha, Nagaraju, Ashok, Ankit and Anita. They kept us comfortable throughout. I thank the protocol, accounts and other sections of this court for the seamless logistic support extended to me. I thank the wholesale Mr. Nagendra for the timely assistance rendered by him. I will always be grateful to my mother Amareshwari, my husband Vijay, my son Gautam and my daughter Mansa for their support and cooperation at all times. God has been kind enough to bless me, such a lovely family. As the Constitution commands and the duty demands, I embark upon a new journey as a judge of the Karnataka High Court. Sometimes we take a path with pleasure, but sometimes with pain. But whatever the feeling, the path remains unaltered, as it is the Almighty that holds the route map. My life experiences have been that I may not always understand God's plan for me, but His rations always turns out to be better than mine. Every time He closes a window, He opens the doors of a palace. It is often said, you cannot discover new oceans unless you have the courage to lose sight of the shore. I would like to add, आगे आने वाले शहर कितने भी खूबसूरत क्यों न हो, पीछे छूटने वाले घर बेचैन कर ही देते हैं. Though my stay has been short, I carry with me the pleasant memories of my days as a lawyer and judge of this court, which I shall cherish for a lifetime. I believe that the world is very small, and I'm sure the paths will cross again in the near future. In the meantime, permit me to extend an invitation to all of you to visit Bangalore. I will be delighted to see you there. My best wishes to each one of you for glory in the profession and for greater glory that you shall bring to the profession. Jai Hind.